Here's the question we're tackling. Can you actually get fired without warning? And if it happens to you, what can you legally do about it? Now, before we dive in, let me paint a picture. You've been working your job for months, maybe even years. You're not perfect, but who is? You show up, you put in effort, maybe you even skip lunch here and there to meet a deadline. Then one random Tuesday, your boss calls you in and boom, you're out. No heads up, no write-up, no, hey, we need to talk about your performance. Just, thanks for your time, we're letting you go. It's gut-wrenching, right? Confusing, even humiliating. And it leaves you spinning with questions. Was that even legal? Shouldn't they have given you a warning? Is this something you can fight, or do you just have to take the hit and move on? You're not alone. According to a study by the Center for Economic and Policy Research, nearly 1 in 5 workers in the U.S. has been fired or laid off without any prior notice. 1 in 5. That's millions of people who just get the boot, seemingly out of nowhere. So in this episode, we're going to break it all down. We'll talk about when firing without warning is perfectly legal, when it crosses a line, and what your rights are if it happens to you. And if you stick around to the end, I'll walk you through what steps you can actually take, legally, if you think your firing wasn't fair. Let's get into it. Okay, so let's start with the big picture. In the United States, most jobs are what's called at-will employment. That means your employer can fire you at any time for almost any reason, or no reason at all, and they don't have to give you any warning. Sounds brutal, right? But it's the standard in almost every state unless you have a contract that says otherwise. So unless you're in a union, or you signed an employment contract that guarantees job security or some kind of disciplinary process, chances are you're at will. Now here's the thing. At will works both ways. Just like your boss can fire you without warning, you can also quit without warning. You don't have to give 2 weeks' notice. That's more of a professional courtesy than a legal requirement. But even though at will gives employers a lot of leeway, there are still limits. And this is where it gets interesting, and where your rights come into play. Because even in an at-will job, you can't be fired for an illegal reason. And if the reason behind your firing breaks the law, then that's where you might have a case. So let's talk about what makes a firing illegal. First up, discrimination. Federal law and most state laws say your employer can't fire you based on your race, religion, sex, national origin, disability, or age if you're over 40. That's protected under laws like Title VII of the Civil Rights Act, the Americans with Disabilities Act, and the Age Discrimination in Employment Act. So if you're let go right after revealing a pregnancy, or if your boss made racial jokes and then fired you when you push back, that could be discrimination. And you might have a claim. Here's a real-world example. A woman in Texas was let go just 3 days after telling her manager she was pregnant. She had great performance reviews and no history of write-ups. Turns out she was fired because they assumed she wouldn't be able to handle the job while pregnant. She filed a claim with the EEOC and ended up settling with the company after they reviewed her complaint. Second, retaliation. This one's big. If you report something shady at work, like harassment, safety violations, or illegal practices, and your boss fires you soon after, that could be illegal retaliation. The law protects whistleblowers. Take this example. A warehouse worker in Ohio noticed repeated safety violations. He emailed management about it, and 2 weeks later he was fired for being disruptive. He took it to the Occupational Safety and Health Administration, OSHA, who investigated and confirmed that his firing was retaliation for reporting safety hazards. The company ended up paying back wages and had to revise its safety protocols. Third, breach of contract. If you have a written or even an implied contract that says you'll only be fired for cause, or after a performance improvement plan, then firing you without warning might violate that agreement. And yes, even some employee handbooks can count as implied contracts in certain situations. Depends on the wording and the state you're in. Also, firing you for taking protected leave, like under the Family and Medical Leave Act, FMLA, is a big no-no. If you were on approved leave and got canned, that's definitely worth exploring with a lawyer. Let's not forget constructive discharge. This is when your work environment becomes so toxic or unbearable that you have no choice but to quit. Even though you weren't technically fired, the law might treat it as if you were, especially if the toxic environment violated your rights. And here's something a lot of people don't realize: public policy violations. Let's say you're fired for doing something you're legally required to do, like serving on a jury or taking time off to vote. That's not just messed up, it could actually be illegal. Or maybe you were fired for refusing to do something illegal, like falsify documents. That's another example where you could have a case, even without prior warning. One more example here. A nurse in California refused to falsify a patient's record to cover for a doctor's mistake. She was fired the next day. Not only did she sue, she won because the law clearly protected her right to refuse illegal instructions. So now that we've covered when a firing crosses the legal line, let's shift gears. What do you actually do if you've been fired without warning? First, breathe. I know it sucks. I've had friends cry in their car, completely blindsided, wondering how they'll pay rent or explain to their family what happened. It's okay to feel all of that. But once you've had a minute, it's time to move into action mode. Start by documenting everything. I'm talking emails, texts, performance reviews, meeting notes, anything that shows how you were treated leading up to the firing. If someone made inappropriate comments, write down what they said and when. If you were praised last week and fired today, save that praise. Dates matter. Next, ask for your personnel file. In some states, you have a right to see it. This can give you a paper trail, or maybe even clues about the real reason you were let go. Then look at your pay stubs, benefits, and final paycheck. Employers are supposed to pay out any unused vacation time in some states, and they have to give you your last paycheck within a certain time, which also varies by state. If they don't, that's a wage violation. And of course, consider filing a complaint. If you suspect discrimination or retaliation, you can file with the Equal Employment Opportunity Commission, the EEOC. You usually have 180 days from the date of the firing, though some states give you more time. If it's a wage issue, check with your state's labor board, and if you're thinking about suing for wrongful termination, that's when it's time to talk to a lawyer. A real one. Not TikTok advice. Not your cousin who took a pre-law class once. An actual employment attorney who knows the laws in your state. Also, don't ignore unemployment benefits. A lot of people think, well, I was fired, so I probably don't qualify. But that's not always true. If you were let go without misconduct, like you didn't steal or violate major policies, you might still be eligible. Apply. Worst they can do is say no. Best case, you get a safety net while you figure out your next move. Now, you might be wondering, do I need to hire a lawyer right away? Not necessarily, but if your gut is telling you something's off, it's worth at least doing a free consultation. Many employment attorneys offer those. They'll let you know if your situation is strong enough to pursue. And if money's tight, look into legal aid organizations or workplace justice clinics. A quick Google search with your city and employment legal aid can point you in the right direction. One more thing I want to mention. If your former employer asked you to sign anything after firing you, like a severance agreement or NDA, don't sign it right away. Some of those documents say you can't sue them or you waive certain rights. Take a beat. Read the fine print. Better yet, let a lawyer look it over before you agree to anything. And hey, this might seem like a weird tip, but talk to your coworkers discreetly, respectfully. If someone else was also fired or experienced something shady, that pattern might help your case. It's one thing to prove you were mistreated. It's another to show the company has a track record of doing this to people. All right, let's recap. Yes, in most cases, you can be fired without warning because of at-will employment. But that doesn't give your boss a free pass to break the law. If discrimination, retaliation, breach of contract, or labor violations are at play, you might have options. And your best move? Stay calm, document everything, know your rights, and get the right advice. If you remember nothing else from this episode, let it be this. Being fired suddenly doesn't mean you deserved it. It also doesn't mean you're powerless. There are laws, systems, and people who can help you figure out your next step. Quick heads up again. This is just legal information, not legal advice. If you've got a specific situation, it's always best to talk to a licensed attorney. Thanks for hanging out with me on the In Plain Legal podcast. If this episode helped you out, check out the one we did on wrongful termination. It goes even deeper into what happens when your firing might have been illegal. Until next time, take care and don't let the law intimidate you. You've got this.